Welcome to this presentation by Facilitators Research. This research is distributed exclusively for informational and educational purposes and does not constitute financial, legal, tax, or investment advice. For such services, you may reach out to speak to one of our officers.
Part 2. Authority of MSM. Section 2.1. General powers of the MSM. Section 2.1.1. General powers of the MSM, 1 of 2. Subject to the provisions of the Capital Markets Regulations, 2014 and these debt listing rules, the MSM has the power to grant, review, suspend or terminate a listing of a debt security or registration of a program memorandum. B. Stipulate from time to time the rules under which a new applicant shall comply before debt securities issued by such new applicant is granted a listing. C. Stipulate from time to time the rules with which issuers shall comply. D. Suspend, alter or rescind a requirement stipulated before or after a listing has been granted. E. Stipulate additional rules from time to time, either by way of amendment to these debt listing rules or by way of the issue of practice notes. F. Stipulate the circumstances under which a listing of debt securities or the registration of a program memorandum shall or may be suspended or terminated. Section 2.1.1. General powers of the MSM, 2 of 2. G. Stipulate from time to time the rules with which debt sponsors shall comply. And H. Stipulate a percentage that is subtracted from the market value of an asset that is being used as collateral or security. Section 2.1.2. General powers of the MSM. The MSM, in consultation with the Registrar of Capital Markets, may grant a listing subject to any additional conditions that it considers appropriate, in which event the new applicant will be informed of, and will be required to comply with any such conditions. Section 2.1.3. General powers of the MSM. Nothing contained in this part shall limit the powers of the MSM, and MSM may at any time exercise any further powers granted to it in terms of the Capital Markets Regulations, 2014. Where the MSM exercises discretion in terms of these debt listings rules, it shall use its discretion in consultation with the Registrar of Capital Markets and, subject to the provisions of paragraphs 2.8.1 and 2.8.2 below and judicial review, and its ruling shall be final. Section 2.2. Suspension of listing or registration of program memorandum, initiated by the MSM. Section 2.2.1. Suspension of listing or registration of program memorandum, initiated by the MSM. The MSM may suspend the listing of debt securities or the registration of a program memorandum and impose such conditions as it may deem appropriate for the lifting of such suspension if either of the following applies. A. If it will further one or more of the following objects and if it is in the public interest to do so. I. To reduce systemic risk, a risk that a failure on part of one or more registered or licensed market participants could trigger the collapse of the entire market. 2. To promote market integrity and investor confidence. 3. To promote investor education. 4. To provide high levels of investor protection. 5. To ensure transparency in capital market dealings. 6. To prevent market manipulation, fraud and other financial crimes. B. If the issuer has failed to comply with the debt listings rules. Section 2.2.2. Suspension of listing or registration of program memorandum, initiated by the MSM. Where MSM intends on suspending the listing of debt securities of an issuer, the affected issuer shall be given the opportunity to make written representations to the MSM in support of the continued listing of such debt securities or the registration of such program memorandum. Such written representation shall be brought to MSM prior to the MSM making any decision to suspend such listing or registration. Section 2.2.3. Suspension of listing or registration of program memorandum, initiated by the MSM. If the listing of a debt security or the registration of a program memorandum is suspended and the affected issuer fails to take adequate action to enable the MSM to reinstate such listing or registration within timeframes as shall be determined by the MSM may terminate the listing or registration in accordance with the set procedure. Section 2.3. Suspension at the request of the issuer. Section 2.3.1. Suspension at the request of the issuer. The MSM may suspend a listing of debt securities or the registration of a program memorandum under the following circumstances. A. Where the issuer is placed under provisional liquidation or under judicial management, or B, where a written request is made by the directors of the issuer in the event of a default of the issuer. Section 2.4. Continuing obligations of issuers. Section 2.4.1. Continuing obligations of issuers. If the listing of an issuer's debt securities or the registration of the issuer's program memorandum is suspended, it shall, unless the MSM decides otherwise, A. Continue to comply with all the debt listing rules applicable to it. B. Submit to MSM a monthly, or such other time period as may be stipulated by MSM, progress report pertaining to the current state of affairs of the issuer and any action proposed to be taken by the issuer in order to have the listing and/or registration reinstated. And C. Advise the holders of debt securities on a quarterly basis or such other time period as may be prescribed by MSM concerning the current state of affairs of the issuer and any action proposed by the applicant issuer in order to have the listing and/or registration reinstated, including the date on which the suspension is expected to be lifted. Section 2.5. Termination initiated by the MSM. Section 2.5.1. Termination initiated by the MSM. The MSM may remove from the official list any debt securities previously included therein, provided that the listing of such debt securities shall first have been suspended when the issuer has failed to comply with the debt listing rules and it is in the public interest to do so. Section 2.5.2. Termination initiated by the MSM. When a listing of debt securities is under threat of termination, the affected issuer shall be given an opportunity to make written representation to MSM in support of the continued listing of such debt securities, prior to MSM making any decision to terminate such listing. Section 2.5.3. Termination initiated by the MSM. If, after a period of 2 years from the date of registration of the program memorandum, no debt securities have been issued under the program memorandum, the program memorandum will automatically terminate and a new application shall be submitted to MSM. Section 2.6. Termination at the request of the issuer. Section 2.6.1. Termination at the request of the issuer. An issuer may make written application to MSM for the termination of the listing of any of its debt securities from the official list and/or deregistration of the program memorandum, stating effective termination date. The MSM may grant the request for termination, provided paragraphs 2.62 and 2.6.3 below are properly complied with, except where all debt securities are owned by the issuer. Section 2.6.2. Termination at the request of the issuer. Prior to being able to effect paragraph 2.6.1, an issuer shall send a circular to the holders of debt securities complying with the following. A. Approval obtained from holders of debt securities following a general meeting for the termination of the listing prior to the issuer making written application for such removal, and B. The reasons for termination clearly stated. Section 2.6.3. Termination at the request of the issuer. Where approval is required in terms of paragraph 2.6.2a, an extraordinary resolution shall be passed by a majority consisting of members holding not less than 75% of the value of a class of notes at a general meeting of holders of debt securities. Any debt securities holder who has proposed the termination will be excluded from voting. This includes the issuer, directors, and any parties acting in concert. Section 2.6.4. Termination at the request of the issuer. Where all debt securities are redeemed, the listing will be terminated once the MSM has been notified and satisfied itself of such redemption. Section 2.7. Censure and penalties. Section 2.7.1. Censure and penalties. Where the MSM finds that an issuer has contravened or failed to adhere to the provisions of the debt listing rules, the MSM may, and without derogating from its powers of suspension and/or termination, A. Censure the issuer by means of private censure. B. Censure the issuer by means of public censure. C. In the instance of either paragraph 2.8.1a or B, impose a fine not exceeding M1,000,000 on the issuer, and/or D. Order the payment of compensation to any person prejudiced by the contravention or failure. Section 2.7.2. Censure and penalties. In the event that an issuer fails to adhere to the provisions of these debt listing rules, the MSM may elect in its discretion that a full particulars regarding the imposition of a fine may be published in any national publications or media, and/or B. an investigation or hearing be conducted and the issuer pay the costs incurred in relation to such publication, investigation, or hearing. Section 2.7.3. Censure and penalties. If the issuer fails to pay a fine or compensation as referred to in paragraph 2.7.1, the MSM may, in terms of the provisions of the Capital Markets Regulations, 2014, file with the clerk or registrar of a competent court a statement certified by the MSM as correct, stating the amount of the fine imposed or compensation payable. Such statement thereupon shall have all the effects of a civil judgment lawfully given in that court against that issuer and in favor of the MSM for a liquid debt in the amount specified in that statement. Section 2.7.4. Censure and penalties. The MSM will give advance notice to the parties involved of any action that it proposes to take under paragraphs 2.7.1 and 2.7.2, and will provide them with an opportunity to make written representations to the MSM. The MSM may act without affording an issuer such a notice if it considers such action to be critical for maintaining smooth market operation or protection of investors. Section 2.7.5. Censure and penalties. The whole or any part of the fines imposed in terms of paragraph 2.7.1 may be used to settle any costs incurred by the MSM in enforcing the provisions of the debt listing rules. Section 2.8. Appeals. Section 2.8.1. Section 2.8.2. Appeals. Section 2.9. Section 2.9.1. Power to require information. Section 2.9.2. Section 2.10. Publication. Section 2.10. Section 2.10. Section 2.10.3. Publication. No issuer or its directors, officers, holders of debt securities or holders of a beneficial interest shall have any cause of action against the MSM, or against any person employed by the MSM, for damages arising out of any statement or announcement made in terms of paragraph 2.10.1.